All right, we've got showing 6 cases. Is that what you're showing?
Yep, that's what we have.
Okay. All right, I'm just going to go ahead and let people in. I'm hoping to take a couple of the cases that I think will be quickly first, but if their parties aren't present, we may have to skip them and come back to them.
All right.
Okay. All right. All right, good afternoon, everyone. I'm Judge Blake Adams. You're here for civil motions hearing docket this afternoon. Today is January 14th at 1:30. We do have 6 cases on the docket. I'm going to try and call them in the order that I think we'll be able to resolve them as quickly as possible so we can get people on their way. Do I have anyone here on Discover Bank v. Delfin Herrera Morera, 18 SC 2698?
Good afternoon, Your Honor. Attorney Rafael Carvalho on behalf of Discover Bank.
Good afternoon. All right, looks like you're here on a motion for change of venue.
That's correct, Your Honor. It looks like after we filed our complaint and we later served the defendant, we came to the understanding that he or she is in Miami-Dade County.
Okay. All right.
So, yeah, we want to move the venue down to Miami-Dade.
All right. And do I have Delfin Herrera Morera or anyone representing that defendant present? Doesn't appear so. All right, plaintiff's motion to change venue is granted. I did review the motion as well as the attachments earlier. And counsel, can you email a proposed order to my judicial assistant in Word format, and we'll get that processed as soon as possible.
We will do that. I will have my office do that, and it should be on the way promptly.
All right, very good.
Great. Thank you, Your Honor.
All right, thank you. Have a good afternoon.
You too as well. Bye.
All right, next I'm going to call on, see if we have everyone here for WW Enterprises of Southwest Florida Incorporated, doing business as Service Master by Right, as well as Janine Pastori.
WW Enterprises
All right.
here.
Very good. And I think I see Ms. Pastori here. Okay, yes. All right. All right, we're here on a pretrial conference. Give me a moment to check the file real quickly. And let me ask, and who do I have with WW Enterprises?
My name is Brenda Schuyler. I'm the accounting manager. The owner, William Wright, will be here shortly.
Okay. And it appears that there was a prior pretrial conference with a mediator back in, it's like October. And then we did an order for a non-jury trial, which was supposed to be on December 9th. And can one of you remind me why that wasn't had?
We were just waiting on the final payment from Ms. Pastore, which we did not have at the time of that hearing. We have since received her payment, so her invoice has been paid in full for the amount due. However, today we're just have the filing fees that do need to be addressed.
All right. So, Ms. Pastore has, you've reached a settlement, is that correct?
I paid them for the work that was performed at my house because my insurance company neglected to do so. And unfortunately, I did close out, sign off my insurance company, and then a few days later was sued by ServiceMaster. But I did only receive one invoice before I received the lawsuit documentation, and it was dated the date of service in October of 19.
Okay. All right. And Ms. Schuyler, do you know how much you're seeking for costs from Ms. Pastore?
We just received the invoice. The cost is $515.
And that's court costs, or what is that?
That's the cost that we had to have the our professional. We have a person that does our filing for us, so that is the exact cost of the invoice that we were charged to do the filing.
All right. Have you provided a copy of that to Ms. Pastore?
Not yet. We just received it.
All
I
right.
need to get her email information if she wants it that way. Otherwise, I can mail it.
Whichever. Both would be great. Just to make sure I have the proper documentation this time, so this doesn't happen again.
All right, Ms. Pastore, do you want to go ahead and provide her with that email address?
We've corresponded before. I believe she has the lascarpa85@gmail.com. LA.
I wasn't sure if that was yours, Janine, but I do have that in my record.
Yes,
Yes.
that would be sufficient.
Okay.
All right. Is there a need to schedule another pretrial conference at this time, or can we just wait and see what transpires between the two of you, and you notify the court of either a dismissal or the need for another pretrial conference?
The fee, $515. It is. I mean, we don't need to reschedule if she's going to review it.
I've agreed to everything, honestly, because I have more serious issues pressing than this, what I believe to be another case of poorly operated companies here in my home.
Okay.
But I will pay the money. I'll pay for your court costs. I'll pay you for your services. And hopefully I'll never have to hear from you or see you again.
All right.
Good.
So it sounds like we don't need to schedule another pretrial conference. We'll just kind of leave the case in limbo until the plaintiff sends us a notice of dismissal, or if one of you feels the need to contact the court to have another pretrial conference.
Perfect. That's fine.
Thanks,
Okay.
Your Honor.
All right. Thank you both. Have a good afternoon.
You too.
Thank you.
Bye-bye.
Bye-bye. All right, let me go to Lansing Building Products v. Omni-Built LLC, 20CC 317.
Good afternoon, Your Honor. Alan Guest on behalf of the plaintiff.
Good afternoon, Mr. Guest.
Good afternoon, Your Honor. Charles Hayes on behalf of Omni-Built and Kenneth Harold.
All right, good afternoon, Mr. Hayes. All right, looks like we're here on a motion for contempt. Is that correct?
That is correct.
All right. Does the defense have any response to the motion? I've already read the motion. I don't know that there's a need to argue it.
No, Your Honor. I was just retained yesterday by Mr. Harold. He's trying to come to the gravity of the situation and get things resolved now. So I'm here today to ask that we have a little bit of time to complete the financial affidavit and potentially try to settle this out and get everyone paid.
All right. How much time does your client need to complete the fact information sheet?
I would say within a couple of weeks, we should be able to have it done.
All right. Mr. Guest, what's your response to that?
Your Honor, I would ask that the court hold the defendants in contempt with an opportunity to purge themselves of the contempt by providing the fact information sheets and supporting documents within, let's say, 15 days, failing which, upon the filing of an affidavit of noncompliance, a writ of bodily attachment would issue. Also asking for $250 as attorney's fees as sanctions to be also paid within the 15-day period.
All right. Any response to that, Mr. Hayes?
No, just, again, we just would like some time, to even maybe to continue this motion for contempt. Just again, he's trying to get things straightened out. He was head in the sand with everything. He's dropped all this on my lap yesterday. I'm trying to help him out. So.
Sorry, I'm looking at my calendar here. All right, well, how about if I do a little bit of a compromise here and I do an order directing that the fact information sheet and any required documentation be completed and sent to plaintiff's attorney prior to January 28th, at which time, if not notified, if the court is not notified that the defendant is in compliance, the defendant will be held in contempt at a hearing to be held on January 28th at 1:30.
Your Honor, are there any other dates available? I know I'm doing federal court on Zoom court at 1:30 on the 28th.
No, that's all I've got for the next several weeks. Perhaps your client will be able to abide by the order and we won't have to have the hearing.
We'll do what we can.
Mr. Guest?
The only other issue is the attorney's fees.
All right. And I will award attorney's fees of $250.
To be paid within that same period of time.
Correct.
I will prepare an order, Your Honor.
All right, very good. If you could email that to my judicial assistant, we'll get that filed this afternoon.
Okay, will do. Thank you, Your Honor.
All right.
Thank you, Your Honor.
All right, thank you. All right, let me go to Port Charlotte HMA LLC v. Eric Rayburn, case number 20 SC 2169. I believe we're here on a motion for summary disposition.
Yes, Christopher Bidoff for the plaintiff, Your Honor. Good afternoon.
Good afternoon. Do I have Mr. Rayburn present? All right, you'll have to unmute your device.
Here we are. Can you hear me now, sir?
I can hear you. Thank you. And you're Mr. Rayburn?
Yes, sir.
Okay, all right, give me one moment to pull up the case here. All right, Mr. Bidoff, this is your motion, so I'll let you go first.
Thank you, Your Honor. This case is in regards to an unpaid medical debt for services rendered at Port Charlotte HMA to Mr. Rayburn on September 28th of 2019. Mr. Rayburn did have insurance coverage that paid the majority of this bill. The original charges were $132,304.46. But Mr. Rayburn's insurance paid and adjusted those charges by $128,134. Mr. Rayburn also made a $100 cash payment towards that remaining balance, so that the remaining balance on that account for that data service is $4,070.46. It's really going through the motion, Your Honor. The exhibits show the documentation of the payment from the insurance, as well as the itemized bill showing all the charges and the payments. Mr. Rayburn and I have engaged in some meaningful settlement discussions. Unfortunately, we have not been able to come to a settlement amount that both parties can agree to. So being that there's no issues of fact that would require a trial, we're here to resolve the case with summary judgment or with summary disposition.
Okay. All right, thank you. All right, Mr. Rayburn, do you have a response to the motion for summary disposition? I know that you filed a response. If you'd like to articulate that.
Yes, Your Honor, we have responded to everything that has been asked of us. I cannot say the same about the other side. We have made several requests as document 8.
Before the attorney was involved.
Before the attorney was involved, that we never was responded to. I asked for, as in paragraph 8, I asked for written explanation, and because their charges were not usual, not reasonable, and not customary. Your Honor, I've had 4 surgeries on my heart. The combined cost of the 3 were less than this one from this hospital. And and it's the same up. I gave them all the medical records. They have it all, and they have refused to even acknowledge it or let us know about it.
Okay.
I gave them all the information, Your Honor, everything they asked for. I even gave them things showing the 3 other surgeries that I had, and they didn't give me the one from this hospital. They just told me that here's your bill, pay it.
The charges from Bayfront are egregiously excessive.
The charges from Bayfront are egregiously excessive, Your Honor.
All right.
I was in there one night, Your Honor, one night.
All right. Any response, Mr. Bidoff?
I'm not fully aware, Your Honor, of what Mr. Rayburn is still seeking from the plaintiff, but in regards to the reasonableness of the charges, the plaintiff's position is the insurance company did review the charges and paid according to the policy terms. Plaintiff is only seeking what's called the patient responsibility after the insurance has reviewed the charges and pays what they're required to. So I would just respond that the charges are the customary charges that of the facility. Also, going back to plaintiff's motion, there is a document attached as Exhibit B, which is a document that Mr. Rayburn signed showing that he was put on notice that the any remaining balance after his insurance paid, he would be responsible for.
Okay.
I agree, Your Honor, but I don't believe that the charges were reasonable. I don't believe they were fair, and I don't believe they were customary. Again, sir, I've had 4 surgeries on my heart, same procedures. They somehow managed to charge more for their one than the other 3 combined, and that's why they had to write off $90,000.
All right, I'm going to reserve ruling on plaintiff's motion for summary disposition. That way I have an opportunity to thoroughly review the motion and attachments, as well as Mr. Rayburn's answer and any attachments he may have included. Let me see where we're at here. Depending on the court's ruling, if the court denies the motion for summary disposition, then the order will also include a court date for a non-jury trial. Obviously, if the court grants the motion for summary disposition, then there would be no further court dates. Any questions about that?
No, Your Honor.
Not from the plaintiff, Your Honor. Thank you.
All right. Thank you both. Stay safe.
Thank you, Your Honor, and thank you, Mr. Rayburn. Take care.
Thank you.
Tommy, what was that case number?
That is 20 SC 2169.
Thank you. Okay. All right, let me go to Shaughnessy Overland Express Incorporated v. Eugene Hamlin, case number 20CC 977.
And Your Honor, Ryan Dugan on behalf of the defendant Eugene Hamlin.
And Phoebe Wise from Hunloger and Parks on behalf of the plaintiff, Shaughnessy Overland Express.
All right, thank you. And I believe we're here on a motion for court's default as well as a motion to dismiss. Is that correct?
Correct, Your Honor.
All right, well, I think we should hear the motion and application for court default first.
Yes, Your Honor. Phoebe Wise on behalf of the plaintiff. Your Honor, we filed a statement of the claim or a complaint back in July of this year. Mr. Hamlin at that time was pro se, and he filed a document that was not responsive or a proper answer. At that point in September, we moved to strike his document, and we came to hearing, I believe, on October 2nd. At that hearing, you did strike his document, and you gave Mr. Hamlin 45 days from October 2nd to obtain counsel if he wished, as he indicated in the hearing, and to file an answer to the complaint. Within those 45 days, he did neither. On November 17th, which was the day after the deadline, Mr. Dugan did file his appearance and requested an extension of time, and then later filed his motion to dismiss the complaint, which is also not an answer, and it was untimely. If you want, I can go ahead and address his issues with the complaint.
Well, let me just get a response from Mr. Dugan regarding the motion for default.
Yes, sir, Your Honor. The facts as stated are, I believe, accurate. I do believe our response came in the day after the 45 days. We did ask for a brief extension of time prior to having that heard. We did file our motion to dismiss, which was filed on or about, I believe, November 30th. There is, I think, a case pretty much directly on point in the second DCA, Your Honor. Russell versus A.G. Edwards and Son, 779 Southern 2nd 452. In that case, the defendant argued that the trial court was not authorized to enter a default based on her failure to defend when she had two pending motions in the trial court, a motion for rehearing or reconsideration and a motion for summary judgment. A trial court may enter a default when a party has failed to plead or otherwise defend. Although Russell had not filed an answer to the complaint, her pending motion satisfied the definition of otherwise defending against the action to preclude entry of default. The second DCA specifically cited to Carter versus Pelican Cove, West Home Owners Association 595 2nd 174, and stating, holding that a pending motion to dismiss precluded entry of a default. My client didn't, or as far as I understand, there's no order that precluded him from being able to utilize his proper responses or defenses. A lot of time we use the term answer in motions for extension of time. And then when instead of filing an answer, we file a motion to dismiss. We are permitted to file a motion to dismiss. There is a reason for the motion to dismiss. There were a few issues with the complaint. There was some things. So we filed a motion to dismiss, which is not yet being heard by the court. That motion to dismiss, we would argue, precludes the court from entering a judicial default, as we are trying to cure what we believe to be a deficiency in the complaint that would enable us to file an answer. To require a defendant to file an answer to a partially pled argument, if our motion to dismiss is found to have merit, which I believe it has merit, whether it's granted or not, another issue. I don't believe my client is prohibited from doing that based on your Honor's order and or the rules and case law in the second DCA and throughout Florida. Again, as far as timeliness, there's case laws all throughout the second DCA in the state that you can file a motion for anything prior to the actual entry of a default being entered, not signed by the court or stated by the court, but actually entered, meaning with the clerk in the file, and that precludes a default from being entered and would require it to be vacated if it's entered after the fact. Mr. Hamlin, due to a number of reasons, he's an over-the-road trucker, COVID-19, whatever the case may be, took a little bit longer than wanted for him to respond. He did hire our firm. We filed a response immediately, and as soon as we could look through it and give a final answer, we did. I think we've done everything, maybe not as timely as it could be, but not against the rules. We do believe a default is inappropriate at this time, and we do believe the case law, especially in the second DCA, supports that, Your Honor.
All right. Ms. Wise, any rebuttal to that on the motion
Your Honor,
for default?
I would like 2 copies of the cases, or at least the site again. I wasn't provided with them before the hearing, so I haven't read them. I can't necessarily respond to those 2 cases. I don't dispute what he says about filing something prior to a default being entered. I do agree with that. At the end of the day, he did not timely file any document. We're here 7 months later and we still don't have an answer to this complaint. We would like to get this case moving.
All right. So I do see that the motion for extension of time that was filed by Mr. Dugan was on the 46th day rather than the 45th day. don't see that an order was ever issued on that. Well, noting that defaults are to be granted sparingly in cases in which it's clear there may be material allegations, I'm going to deny the plaintiff's motion for a default at this time. That brings us to the motion to dismiss the complaint.
And if I may briefly, Your Honor, Ms. Wise, I'll send that case over to you as soon as we're done.
Thank you.
You're welcome, ma'am.
All right.
Would you like me to begin, Your Honor?
Yes, go ahead.
Your Honor, our motion to dismiss actually had two issues. One of them has been resolved just after I logged in for our hearing. I received from Ms. Wise's office what appears to be a completed document, and I'll go over which one of the two issues. We raised two issues, Your Honor. The first one is the plaintiff stated that they have included with their complaint an exhibit which appears to be some sort of a contractual agreement between the plaintiff and the defendant. That document is incomplete. If the court looks at it, it states, it doesn't have page numbers, but it does have paragraph numbers. It has paragraph numbers 1 through 13, clearly legible and noticeable throughout the document. Then it jumps to paragraph 16. I don't know if there's 1 page missing, 2 pages missing, but there are some pages missing. They're claiming a breach of contract. In order for me to determine what contractual obligations each party had to one another, I believe I would be entitled and need a completed contract in order to give a possible, proper, and complete defense, or at least an answer to the complaint, with a contract being alleged to have been breached. The second issue, Your Honor, is the one that's been cured, I believe. So I'll withdraw that, but there was a page 10 that had some numbers on it. I don't know what that came from. I have now received a document numbered 1 through 10, and page 10 is the document that was attached that I mentioned. So I believe I now have the entire document that deals with that. So I don't believe that's an issue anymore. So I would just argue under 1.130 sub A, Your Honor, that requires all bonds, notes, bills, contracts, specifically contracts, to be attached that are at issue in the complaint. And the complaint is a breach of contract, that the entire contract has to be attached to the complaint, so I can give my client a proper response and an answer and potential affirmative defenses, instead of guessing what might be contained on those pages, or having to amend later. That's our issue, Your Honor, and that's all I have.
Okay. I do see where the what appears to be a contract ends at paragraph 13 on page, this would be 17 of 25 that was filed, and then on page 18 of 25, presumably it starts with a paragraph that was under section 15 and then goes to 16 and then signed. Ms. Wise, any response?
Your Honor, this is the contract that we have that Mr. Hamlin signed. Shaughnessy Overland generally uses essentially the same contract for every client or employee. I can give him the language that's missing, but we don't have the page. This is the contract we have. His client was given a copy. If he thinks his client has a different contract, he can provide it. What I submit to the court is that 14 would say descriptive headings if it were in fact in this document. And that would say the headings used herein are descriptive only for the convenience or identifying provisions and are not determinative of the meaning or effect of such provisions. And that 15 is titled Opportunity to Consult with Counsel. And that section is actually what is above on the last page of waiver. So that's the part that he seems to think is missing. As I said, this is the contract we have that he signed. So I don't believe any part of it is missing. If a part of it is missing, it's not material, and I would direct him to the part that says a copy of the portion, therefore material to the pleadings. That's, this is the contract we have, Your Honor, that he signed.
Mr. Dugan.
Your Honor, if there's a page that's supposed to be in there, I mean, if he signed an incomplete contract and they want to acknowledge that, that's fine. If they want to amend it and add the page that's missing, for them to say it's not material, great. But if we just took plaintiffs for their word, then there would be no need for defense counsels and there would be no need for defenses. I agree that Ms. Wise is probably accurate. I have no reason to believe she's providing anything false to the court, but her statements are not facts. Her statements are not the document. It does seem to have that indication in the paragraph above number 16. But again, if you're going to claim breach of contract, you either have the full contract or you need to plead that the contract in the possession of them is incomplete and we are suing on an incomplete contract. Because if I go to court and to trial and they go, oh, nope, there's another page here. Here's what it says. They can't testify to it if it's not in the document, and they can't just show up and go, oh, no, here's it is. It's not material. We don't know why we didn't give it to you before. They either need to add it or they need to replead that they are going on an incomplete copy and asking the court to enforce a incomplete signed contract, which raises additional defenses for us, including whether or not a partially written contract can be enforceable or if it now becomes verbal. Because if you don't have the complete contract, it'd be like having the Bill of Rights, Your Honor, and not given the page where they revoked prohibition and people go, oh, great, we can't have liquor. No, we can. Well, but that was immaterial. We forgot to add the page. We can't find it anymore. If you have it, put it in. If you don't have it, you need to inform the court and state in your complaint you don't have a complete contract.
Ms. Wise.
Your Honor, that's not my position at all. My position is that the contract we've attached to the complaint is the copy that he signed. If, that section was not in the copy that he signed, then it wasn't in the copy that he signed. I mean, this is his complete contract.
All right. So what you're saying is there's no page that has paragraphs 14 or beginning of 15. That's my understanding, Your Honor. All right.
Then, Your Honor, I'm fine with the denial of our motion to dismiss with the finding that the contract that's attached is the full and complete document, so I can then prepare my defenses.
Ms. Wise, do you agree to that?
That's fine, Your Honor.
Okay. All right. I will go ahead and dismiss defendant's motion to dismiss the complaint with the finding that the contract attached to the plaintiff's complaint is the full and complete contract. Mr. Dugan, I'm assuming you'd like that extension of time to provide an answer at this time?
If I could, Your Honor. Let's see, today, if I can have, I know normally it's 10 days. A lot of people ask for 20. If I can have 15 days, Your Honor, I'd appreciate it. I need to look into potential defenses regarding an incomplete contract or potentially incomplete contract that was signed with provisions not fully vetted.
Any objection to 15 days?
No, Your Honor.
All right, and I'll grant the motion for extension to file an answer in 15 days. Mr. Dugan, can you prepare a proposed order and email that to my judicial assistant?
I will, Your Honor. I'll send it to Ms. Wise, and then once I have agreement, I'll get it over to the court. Would you like me to do both, Your Honor, or Ms. Wise, do you want to do the one on your motion?
Ms. Wise, if you could do the one on your motion, and then Mr. Dugan, if you could do the one on your motion, we'll we'll split it evenly.
Yes,
Sounds
Your
good, Your
Honor.
Honor.
Okay, anything else we can address at this time?
Not for me, Your Honor.
No, Your Honor.
All right. Thank you both. Have a good day and stay safe.
Same to
Thank
you,
you.
Your Honor. Thank you.
Thank you.
Your Honor, on the Lansing building against Omnibuilt, was that motion for contempt granted or denied?
It was deferred, I guess.
Okay.
Let me see what I said. Yeah, it was basically deferred to January 28th.
Okay. Thank you.
I'm showing that we have one more case.
Yeah, Webster against Matter Brothers.
Let me see if Julianne has heard from either. Well, I doubt we'll hear from Matter Brothers because we entered a default.
Okay.
Let me see if she's heard from Ms. Webster.
Okay.
Okay. All right, she has not heard from her.
Okay.
So I don't know. Hang on a second.